I now have the pleasure of introducing our interactive mock sentencing workshop with Judge Nancy Gertner. This is an innovative and engaging presentation and discussion in which the participants will delve into the particulars of a real, complex case. They'll evaluate varied sentencing recommendations, hear expert perspectives, and discuss the appropriate sentencing outcome. At the end, the judge will reveal to all of us what actually happened in that case. Moderating this panel is the Honorable Nancy Gertner, former United States District Court Judge for the District of Massachusetts and Professor of Law at Harvard Law School. I personally have had the pleasure of participating in meetings with Judge Gertner in Los Angeles, in Washington, D.C., and in New York. Judge Gertner is indefatigable, courageous, brilliant, and relentless. She also taught me that former federal judges do not have to go through security at TSA. But not the people who are accompanying them. They still do. Judge Gertner, on behalf of all of us at Aleph, I thank you for the countless hours that you provide to Aleph pro bono and your deep and enthusiastic commitment to helping in so many ways, whenever and wherever we need you. Thank you.
This is not a panel. This is me. And it's pro bono? Never mind. It's wonderful to be here. This presentation comes from teaching that I've done for nearly 15 years on sentencing. But more significant, comes from teaching that my mentor, Dan Fried at Yale Law School, did for 20 years before that. What am I talking about? Long before guidelines, long before even mandatory minimums, Dan Fried had a symposium for state judges. And the state judges would come to Yale Law School and spend 2 days working on actual cases with the students. Cases would be presented, and everyone would determine what they thought the sentence would be, and everyone would talk about each other's sentences and what the rationale was. This was before guidelines. And the notion of that was first to try to determine what the standards of sentencing were, to try to get at a common law of sentencing, a judge-based standard of sentencing. And then to talk about disparity, because if you listen to what your colleague was saying, you would say, you know, that actually was a good idea. Maybe I would do something different. And the notion was that when you talk to one another, judges could come to more aligned sentences. The sentencing guidelines trumped all of that. Sentencing guidelines took away all of that in the federal system. And even then, with my class at Yale and with Dan and with others, we would take a case, much like the case I'm going to present to you today, and we'd have everyone sentenced, the students as well. In fact, this is a case that my students and some federal judges sentenced just this spring. And again, there'd be a discussion, not just of what the guideline calculation was, but why. What was going on? What made a difference? And that's what I want to present today, the hard cases. So let me start off with general principles because I have the microphone and I can't help it. Less incarceration is not a criminal justice policy, any more than more incarceration was. But that seems to be all that we're talking about, less incarceration. Criminal justice policy had to do with the kinds of issues people have been talking about today, which is the why of crime, the how of crime. Not just more or less, and to some degree the more or less discussion suggests that we're still stuck in imprisonment, we can't get out of it. More judicial discretion is not a criminal justice policy either. I was a defense lawyer at a time when there was more discretion, and many state systems have total judicial discretion. And it sounds wonderful, except if judges don't know what they're doing, it is irrelevant. And what happened in the past was that there was considerable judicial discretion. We talked about rehabilitation, and it was faith, not reality. It was not science-based. It was not based on the neuroscience of addiction. It was not based on studies about adolescents. It was not based on anything other than a judge's gut. Small wonder, then, that that moment in rehabilitation failed. So more judicial discretion is good, but only the beginning. We have to ask what we're trying to accomplish. We have to figure out what's different about rehabilitation today than it had been in the past, why it failed in the past, why it was discredited. One of the advantages of being old, which is really, is that I have a long memory here. In 1985, when the sentencing guidelines were passed, the predominant book said, "What works? Answer nothing." And everyone, including progressives, abandoned rehabilitation. Progressives, the American Friends Service Committee, abandoned rehabilitation because it had led to racial disparities, it had led to longer sentences. You need this amount of time to rehabilitate you, because there was no content there was no theory there was no analysis. So we have to make sure that what we're doing now is different than what we were doing then. What are we doing today to avoid the backlash? I don't know if Rachel Rollins is still in the room, but I keep on telling her that you have to tell the press about the cases that worked. The media is structured to only talk about the cases that didn't work, to talk about the judges who didn't accept the prosecutor's recommendation and therefore wound up and gave a lesser sentence. We have to explain what we're doing to the public, otherwise we will have a backlash. In the first case, in which the defendant goes through a reentry program and then reoffends. We have to tell the non-offending stories. How much of a change are we making? It's wonderful to be here, but there's almost as if we have multiple systems of punishment here. We have the diversion systems, which are wonderful, in which we take, I don't want to say cherry pick, but we take out of it the people that we think can succeed. Then we have a mandatory minimum world, which is like La La Land. A mandatory minimum world which has nothing to do with any of the things that we're talking about. Then we have in the federal system a guideline world. And the case I'm about to present to you will show you what the guidelines have done to this discussion. And those worlds are different. I would love to see those of you who have important rehabilitation alternatives to incarceration programs, I'd love to see you tell the sentencing judge what works. In other words, you have learned from your pretrial diversion programs, the front end should provide data for the back end, so that the front end should teach us what to do. In this case, we'll describe that about addicts, about mentally ill. And even if they're then not in a diversion program, those insights of what works should go into the back end. Otherwise, we're going to be continuing what is essentially a trifurcated system. We have to deal with the violent offender. I'm about to show you the case of the addicted bank robber. We have to talk about what is violence and what is not. I didn't think I was going to do this, but I think I have to. Judge Block talked about his book. I have a book. I have a book which is relevant to the violence question about the men that I sentenced. It's called Incomplete Sentences. And it's about the men that I sentenced because I had files on each of them. And I have been interviewing them since I left the bench. And Incomplete Sentences, so is my story, and it is their story, and it's the story of being a judge in a regime with which I completely disagreed. How does one deal with that? It's relevant to the discussion of violence because in talking to, it's about 15 men that I've interviewed. In going through their records, every single, there's a part in the pre-sentence report which says physical condition. And what I have found is that literally all of the men in one particular, quote, gang that I was sentencing bore the marks of physical violence on them. One had a bullet in his brain, one had knife marks on his body, another had the marks of where he'd been beaten as a child, marks that didn't go away. All of them had that. But so the question of what is violence, Bruce Western of Columbia Sociology writes that what is violence is oftentimes happenstance. All of these men were either victims of, witnesses to, or perpetrators of violence. And until we begin to deal with what that means, we're not going to do very much at all. We have to deal with violence. We have to deal with second or third offenders. I'll get to my drug-addicted bank robber in a moment. We have to deal with addiction. The sentencing guidelines told us that addiction was not ordinarily relevant. What planet were we on? Addiction is virtually always relevant in these cases to some degree. We have to deal with racial disparities. Concern about the nature of the disparities even in our diversion programs. We have to take a look at that. And we have to talk about efficacy. Now, I know people have talked about the efficacy of alternatives, and I agree with we have to talk about that, but when did we ever talk about the efficacy of imprisonment? I think that that's a discussion that we should have by comparing prison to these programs. We know that prison is not efficacious, full stop. What are the impediments to change? We've seen some of them today. There is a culture of mandatory sentencing. Larry Krasner was described in the paper the other day as having been criticized by a judge for the proposals that he was making. The culture of mandatory sentencing and the culture of retribution, after 30 years of a retributive model, we have to undo. And in part, we undo this through the media. Judges have become immunized to imprisonment. Again, Krasner's comment about 5 is the new 1, or 5 is the new 1. And that's right. We've come used to 25, 30-year sentences, whereas 30 years ago, half of the federal population got probation. Now it's perhaps 5 or 6%. We have to deal with the absence of alternatives. That's why we have to deal with ordinary sentencing. In ordinary sentencing, we can't say, I'm going to send you away as I did as a judge. This book is very personal. I don't know what to do with you, sir. There are no alternatives that deal with you, and therefore prison. We have to deal with the absence of alternatives. Judge Weinstein wrote a very eloquent decision in a drug case, a gang case, in which he talked about how incredibly complicated the backgrounds of the men he was sentencing were. These are the same that I'm seeing. And he said, what do I do with them? What do you do in a community which doesn't have these alternatives? And so the default became prison, clearly out of proportion to what we should have done, but the default became prison. We have to talk about alternatives in ordinary sentencing, not alternatives to incarceration, but we have to talk about alternatives. Lurking in the background is some fancy PhD student who is going to discover disparity in sentencing. Zut, there is disparity in sentencing. And there is disparity in sentencing in the federal system because there are guideline judges and non-guideline judges. And that, because we have not seriously thought through the what to do, the how to do it, the default is going to be guidelines. If we haven't determined a way of talking about what we're doing that is coherent, that makes sense, the default will be guidelines. That's what's happened before. So the battle cry of disparity, the Willie Horton fear coming from Massachusetts. Willie Horton was the defendant, as you know, who was released and committed another crime. Rape was a black man who raped a woman and killed her husband and her. Willie Horton has stopped criminal justice reform in Massachusetts for years. Progressive Massachusetts can't get anywhere because everyone worries about Willie Horton. We've had some changes this past summer, but nevertheless, my point is the larger one, which is we have to deal with the inevitable failures by talking about the successes. We have to immunize the public to that, because that will come. The sentencing guidelines came out of the death of Len Bias, a Celtics player who in fact died of a cocaine overdose. And that triggered basically legislation by anecdote. We've dealt with 30 years of the decline of expertise. One of the things about a retributive system, as opposed to a rehabilitative system, is you never ask the question of what works. You never ask the question of what makes sense. You say, what does the crime deserve? And every shock jock can figure out what the crime deserves. We have to go back to expertise. Law of neuroscience and of addiction, the neuroscience of mental health, of adolescence, psychological advances. We have expertise now, which then bears on the disparity issue, because if you ground your sentence on expertise, you're not determining it on the basis of your gut. And there is no law of proportionality. We've lost all sense of whatever anyone did, it didn't deserve 25 years. The only thing in my book as I go through these sentences of the men I sentenced, what I did and what I knew and what I've come to know, sometimes I get to the point where I say, I'm not sure what I should have done for them. I'm not sure what I should have done for the guy who had a bullet in his brain permanently. I'm not sure what would have worked. But one thing I knew is what I did was wrong. Not wrong legally, but wrong in terms of any meaningful criminal justice system. So sometimes that we need to develop a law of proportionality. So I want to deal with the hard case, not the easy case. This is a guy who couldn't be diverted. This is the case of the addicted bank robber. And I think every federal judge in this courtroom probably has had many of these cases. I know that in a PowerPoint, which I hate, I'm supposed to do a funny picture. So that's the funny picture. Stick up is one word. Okay. That's the end of the funny pictures. That concludes my expertise with PowerPoint. Now we're just talking text. This is the case for all of you. It's a real case in Massachusetts. A 60-year-old defendant, he has no high school diploma or GED. He's charged in a one-count indictment with bank robbery. It's a guilty plea, no plea agreement, just basically throwing himself on the mercy of the court. Here's the robbery. The lawyer called it a note job. Saturday night, the note job in distinction to the Italian job, right? This was not the Italian job. 9:45 a.m., he entered the bank holding a note that said, "This is a robbery and gun." He gestured to his pocket, no gun was shown. The robber pulls down his face mask, also a really intelligent thing to do, so that he can show his face, just in case the cameras didn't catch all the details of his face. The teller handed the robber $6,129. He's apprehended within a day. Actually, this was a relatively long apprehension. This usual category, I had one guy who went into the bank, stuck his finger in his pocket, walked out covered with the dye pack, and waited for the police to come and get him. Surveillance cameras capture the robber getting into the car. The car is registered in his name. It's traced. So he's getting into his own car. Okay? Surveillance video captures him getting into his own car. Car is traced to him, and he's on probation, so that's really pretty easy to trace. Within a day, he's arrested. I'm going to tell you the clinical narrative about this man based on the materials that we had. And I'm going to tell you, the judges, the clinical narrative first before I tell you the guideline narrative. Because looking at the clinical narrative first changes your view of the outcome. If you tell the story first, it changes your view of the outcome. This was not as bad a background as actually I had seen. The ACEs score would not be a very high score. It's not as bad as what I've seen, except for the addiction. Single alcoholic mother, father died, brother's in prison, sister works in healthcare, dropped out of school in the 10th grade, no clear work history, although as I said, there's some indication he's a talented painter. By the way, the dropped out of school in 10th grade, all of the men in the book that I've studied from this one gang were kicked out of school in the 9th grade. The school had lost its accreditation. I didn't know any of this when I was sentencing them. The failure of the school system was so fundamental. Significant cognitive impairments, likely linked to lifelong addiction, and likely linked to lifelong addiction that began at a very young age. Judge Salas was talking about that. Sustained heroin and cocaine use, bipolar disorder, anxiety, depression, panic attacks, lifelong substance abuse. Crack, cocaine, marijuana as a teenager, binging on both crack and heroin sometimes 24 hours a day. The record reflected that he continued to use in prison. What a shock. He continued to use on supervision. His criminal record from a clinical perspective, this is not adding up scores. His juvenile record that began with larcenies at age 8, which was roughly the same time that he was starting his drug abuse. In his 20s, they were larcenies with small amounts of money, but in his 20s, there was no question there was some armed robberies and some gun possession cases. Every time he went to prison, he had disciplinary reports. Post-incarceration, he was constantly getting into trouble. At age 35, he perfected bank robberies that were unarmed. All of them were note jobs, all primitive, poor disguises, always used his own car for escapes. He'd leave a note with his fingerprint on it. The immediate prior offense, he's now 60. He had the 13 years before was another bank robbery, the immediate prior offense. Then something changes. I don't want to pretend that it was, all of a sudden he got religion, perhaps. All of a sudden something changes. The Massachusetts Care Program, with Judge Sorokin started, was where he went after this latest imprisonment. And for the first time, something is working. Not immediately, there were relapses. He receives drug treatment and now treatment for co-occurring disorders, the mental health and the drug issues. He begins to attend psychiatric visits, sessions. He begins to take a mood stabilizer. He's on Suboxone. He's drug-free except for the Suboxone for the very first time, we think, in his life. He marries a female resident of a shelter in which he's working. He adopts her 3-year-old daughter. He tells the probation officer he wants to be the father he never was to his previous children. He did well for the first time in his life. I put well in quotes. The measure of well is different for this man than it would be for others, but he is doing well for the first time in his life. He's drug-free. The clinician believed. This is interesting. The clinician asks the question of why. When I was on the bench, we never asked why. You never asked why. You asked criminal record and offense conduct. You never asked, why did you do it? What made you do it at this point in your life? Will what you did recur? Is that likely to happen again? But she asked him why. This was a robbery born out of habit, poor coping skills, no working skills. And later on she describes, all of a sudden he took on too much. He took on too much. I'll get to that in a minute. She wants a long-term, or wants us to consider long-term residential treatment, or at least considering that. She wants to evaluate the nature of his cognitive impairments to determine if they're going to require sheltered housing and work situations. She didn't give a final determination, but she thought that there was something there. The government's position. You've heard this before. The government's position, this really goes to the guideline issue. The government's position was he had a weapons offense. Yeah, he had a weapons offense when he was 15 to 17. He's 60 now. He was unwilling to refrain from criminal behavior. He was addicted. Doesn't take away his moral agency. That's a longer discussion. But it certainly means unwilling is an interesting concept. He refuses to rehabilitate. Not sure that anyone went back to see what was offered to him, what treatments were available. The defendant's position, which is more, I put more in here because the defendant's position, actually the defendant had more to say. And here was the point where I call attacking the criminal law tropes. And in writing about the men that I sentenced, I find myself reading my own transcripts and going, God, did I say that? I really recommend you don't do this. And one is, instead of doing the same thing and expecting a different result, this court should order him to do what he's never done: long-term residential drug treatment. The criminal law trope was, Mr. Smith, Mr. X, you screwed up every time I sent you to jail, therefore I'm going to send you to jail more. A dozen years incarceration warehouses an individual whose circumstances call for treatment and rehabilitation, especially since incarceration has been tried repeatedly and failed comprehensively. Addiction, defense lawyer said, was a relapsing disease. The defendant could have had, this is what was significant about the care program, could have had two responses. One was to spin out of control, and the other was to try to go back to sobriety. And that's what he tried to do. And what was the why? He went too quickly from a released convict to a new husband, father, and sole provider, needing to make rent and car payments. As life's pressures mounted, he began to drink. When an eviction notice arrived, drinking gave way to cocaine. The disease was reactivated in his brain 2 weeks later he handed the teller the note. The lawyer talked about not just the neuroscience of addiction, talked about recidivism studies with respect to age. One of the problems with guideline sentencing is we stopped talking about these issues. I like to describe it as guideline speak, basically suck the air out of all other discussions. Age. He was at the point where the risk of recidivism was at a statistical ebb. Older prisoners require more health care, and the proportionality line, increases in the severity of punishment do not yield significant marginal deterrent effects. So putting him away for 151 months for the purpose of affecting his behavior was unlikely. The defendant's recommendation was time served. The defendant's recommendation was time served. The government's recommendation was 151 months. What's a mother to do? There was a silly commercial on television. Remember, she looked at the camera and said, "What's a mother?" This was a moment that I felt, when I was a judge, I would feel like I'd want to go, my God, what do I do? Time served versus 151 months. What to do? Questions? Suggestions? Anyone have any idea? What would you do? Ordinarily, we would have judges who will have read these sentences, read this hypo, who would sentence the individual. They would give me their sentences in advance. I'd put them in a book. We'd chart them on the chart. Everyone would talk about one another's sentencing, and you'd decide what you thought was appropriate. And after you gave me your sentences, and I put them in the book, and we talked about it, we asked whether you changed your mind after talking to each other. The model is like a clinical model. That's what doctors do. Let's talk about this and we'll think about what works. So what would you do? Anybody? Yes.
I'd put him in rehab. Is this on?
Yeah, it's on.
I've done this, not this case, but other cases just as graphic. Put him in what I call preentry court. I tell him, I bring him in, sit him in chambers, prosecutors there, pretrial service or officers there, probation officers there, defense attorneys there. I say, I'm not going to sentence you today. I'm going to put you into this to the extent we have a long-term rehab, and I don't know what you have, but ours isn't enough. I'm going to come back in a month or two and see how it's going. If it's going well, I keep it going. And when I do this and it works, doesn't always work. At some point, even the prosecutor comes in and says, "Judge, we get it. Give them whatever you're going to do. We know what you're going to do because you're not going to send them to prison." And my view is, why send them for any time when we're going to put him in reentry court afterwards? He's the kind of candidate automatically goes there. And candidly, Judge Gertner, it works, not all the time. But use the discretion we have. You're so right. So many of us think that guidelines are gospel. We're scared that they're not. They're optional. I view January, I think it was 25th, 2005, when Stephen Breyer, responsible as far as I'm concerned, largely to a considerable extent for the guidelines, the Sentencing Reform Act, had his public mea culpa. The way the Parisians view August 24th, I think it's the date, 1944, the liberation of Paris. Booker set us free, and I'm afraid all too few of our colleagues get that. We have to learn and understand, correct me if I'm wrong, it takes approval of the Office of the Solicitor General of the United States for the government to appeal one of our sentences. Be sensible, be rational, state why you're doing, and sooner or later, the prosecutor's office is going to get it and understand.
The appellate courts are virtually not reversing judges.
Right.
So that gets to the culture of that I was talking about. You have to ask the question why the guideline, following the Sentencing Commission issues studies that say that judges follow the guidelines 80% of the time. That isn't exactly true. What they mean is they follow them 50% of the time, but 30% of the time are the cases in which the government agrees. And the commission counts that as an 80% time. In no other country in the world is your discretion determined by whether or not the government approves. The notion that that counts as guideline following says something about how far we have gone. But the judges, for the most part, now there are jurisdictions in which judges are being reversed for being outside the guidelines, and this would be a vulnerable sentence in some jurisdictions. Certainly in the First Circuit, it would have been. If I did this, I'd be reversed in a nanosecond. A little longer than that. So there's certainly some vulnerabilities. But your point, which was well taken too, is that what if the judge then said, I'm grounding this variance, let's say, on addiction, mental health, the issues of age. I'm giving it a grounding. We have a theory of guidelines, but we have no theory of variance. And until we begin to, and therefore everybody gets drawn to the guidelines. And until we have an articulated theory about variances, then that would make a difference. So is there anyone here who would do something different? Yes.
I had this exact same case, almost exactly the same, except there were 3 bank robberies before the last one that he was in front of me on. There was one additional exception. When he came in to be sentenced, he said, I've sold everything I have and arranged for a year-long in-house treatment program and a faith-based program in Lansing, Michigan. So I delayed his sentence for a year. When he came back, he had successfully completed. He had been married, become involved in the church group, had employment, had not tested positive for the entire time, and was taking care of a 3-year-old granddaughter. I sentenced him to time served and continued a supervised release for, I think, 3 to 5 years. I forget exactly what. The government had asked for 10 years in his case, 120 months. They appealed. The 10th Circuit said, you abused your discretion because you considered all of the factors under 3553, but you didn't take into account the requirement that you punish him. So they sent it back to me on remand. I read the remand as saying, do it again. And so this time we had an evidentiary hearing. We had 12 witnesses. All of his supporting providers came in and testified that imprisonment at this point in his life would cause a significant relapse, and that it would involve that he was doing everything that he was supposed to be doing. He'd been clean now. Now we're approaching 4.5 years since the crime was committed because of the time for the sentencing and the appeal. And so I wrote a 61-page opinion going through each of the sentencing factors. It went up then a second time to the 10th Circuit Court of Appeals. This time they said, they spent 10 pages talking about whether I had misread their remand instructions. But then they concluded that they weren't going to address the substantive issues because the government hadn't properly preserved that argument. So my question is, we need a fundamental change in terms of the way the appellate courts are looking at sentencing if we're going to achieve the objectives of being able to. This man was completely rehabilitated. There was no purpose at all. One of the things I wrote is just punishment without serving any purpose is not just. And the 10th Circuit didn't like that decision.
One of the things that happened with the guidelines is that again, comes from being old. We never had appellate review of sentencing on the federal side.
Yeah.
There was no appellate review. So suddenly with the guidelines, appellate judges some of whom had never sentenced, suddenly were reviewing district court sentences. And because all they knew was the guidelines, What happened across the country was that they enforced the guidelines with a rigor that nobody ever anticipated. The First Circuit became the Guideline Police, and if Gertner stepped over the line in any way, I would write decisions in order to deal with their anticipated, in my view, ridiculous decisions. So and what's interesting is that we have these wonderful programs in which you invite trial judges but not appellate judges. And it's the appellate judges who don't understand, who only know the guideline book, because that was law, and don't know all the other things that people are dealing with. In this situation, the guideline was enhanced because of a gun. Guy didn't have a gun, but the guidelines suggested that you could enhance if a gun was brandished, and it didn't matter that he didn't have one. When you tell someone, I have a scientist friend of mine who sometimes I will tell him about court issues, and he'll say, "Is that a thing?" And I'll go, "Yes, that's a thing." So that you could enhance this for a gun, that's what it was in the guideline, that for a gun when in fact there was no gun, but there's a body of law that says you can do that. Essentially, the guideline law spun out of control as abstractions and more punitive. The guideline was 22 because he was a career offender. The guideline history, the total was 29, a criminal history of 6. The career offender guidelines, everyone can depart from a career offender guidelines, but it drove up the sentence. The guideline range, as I said, is 151 months. I gave this is the second year I gave this to my class. The probation officers in the class said they had no choice but to recommend the guideline sentence. They were essentially defanged by the process. They had no choice. So they came in with the prosecutor and then the probation officer both saying 151 months. The judges were between 72 months and 151 months. The judges who had had time to think about this were between 72 and 151 months, because they felt that anything further from the guideline range was dumb, was crazy. Anything further from the guideline range would enhance the likelihood that they would be reversed. My students, who were fabulous, gave between 3 years and 10 years, so there. So one question to judges here is that I skewed this presentation by talking about the clinical narrative first. The sentencing judges are supposed to look at the guidelines first. Would the outcome have been different if you started with 151 months than if you started with the narrative? In other words, to say that the guidelines are advisory and that they anchor our framing of this actually understates the problem. If you see this as a 151-month case, will you be able to see it otherwise? How many of you ever begin with the narrative as opposed to begin with the guidelines? Yes, tell us how.
I always begin with the narrative first, even though we are constrained to begin our evaluation with the guidelines, but it's a person before me and not a guideline. So I begin with knowing the person, because if I'm going to, because if I'm going to sentence a person, I want to know who I'm sentencing and get some idea of his or her background and let that frame my analysis. And I do it because I can. I have life tenure.
Yes, go on.
In our district, the guideline range is one of the very last things that is given in the pre-sentence report. So, yes, in our district, the guideline range is one of the last things that's provided in the report. So you have walked through the offense conduct and their background and their history and everything before you ever get to the guideline range. So if you read it in order, you get all that first.
Do you have a recommendation that derives from that? I know that's the structure of the pre-sentence report. That's right. In other words, you get a clinical narrative that ends with this is who the person is, not this is what we recommend. Then you get a guideline version that says 151 months, and then you're to try to figure out what the appropriate sentence should be. In fact, that's entirely fair. I tell my students, I tell the judges that I teach this to, that it's not just that, first of all, it's a paper record, and you have a person in front of you, and the person can make a difference. And it's also a very truncated record. There's no question about that. But the teller will say, that in fact she was put in fear. The teller will say that she was put in fear. She didn't know that he didn't have a gun. She didn't know that he never had a gun. So she was put in fear. But the question then is, the guideline framework says that that trumps everything. And the question is whether that makes any sense. In other words, the guideline, I want to do this as a closing for all of you, but the guidelines essentially flattened offenses. So bank robbery became bank robbery, and we didn't have bank robbery with a note. We didn't have a category. If we had bank robbery with a note, maybe we wouldn't have started at 29. Maybe it would have been much less. Maybe if judges had had an opportunity to say, there's really a difference between the sophisticated bank robber on the one hand and the addicted bank robber on the other. But that was really, the guidelines forced us to come to a number because they were all treated the same, and then depart from it. And in some parts of the country, that's not an easy thing to do. This to some degree is a skewed group, because the judges in this audience are the judges who wanted to come to talk about alternatives to incarceration. The judges in my class, that we'd invited to my class, were coming not for that purpose, and their ranges were very different because they basically felt moved by the guidelines. But it really relates to what you were saying, which is this system, which we are supposed to credit, is broken in fundamental ways, and it skews the analysis in all these directions. The judge in the case, I'm really blown away by what you all have done. The judge in the case, essentially, Judge Zobel, has been on the bench for a very long time. She deferred sentencing for a year and had him continue what he was doing. And then at the time of my class, we didn't do this intentionally, but it turned out that at the end of that year, she sentenced him to probation. And he is still doing fine. But how many of you have had the addicted bank robber case? How many of you have had this? Really, it is a profile. So here's a suggestion. Judge Zobel didn't do this. She just sentenced him. But if we came up with a case study of addicted bank robbers, in which we talk about what neuroscience did, what the addiction studies do, as a template for other judges. I used to write decisions because I just love to write. But the purpose of this would be, you want to talk about disparity? Well, then the next time you have an addicted bank robber case, you'll look at it differently. And across the country, you'll look at it differently. And if the sentencing commissions had case studies rather than numbers, maybe we would all be more in line. Yes?
Talking from a trial court, a state trial court's perspective, where we don't have sentencing guidelines, and a lot of this conference has been focused on that, and for state trial court judges, this is very different. I'm given maximums, but not minimums, so I have a lot of flexibility in my sentencing, and yet I'm finding that my colleagues who do have a lot of the flexibility in sentencing and are not bound by the same kind of guidelines that the federal judges are bound by are still not utilizing these creative solutions. So it's not just the guidelines that are the problem. It's the education, the mentality, it's the willingness to put in the work. It's much easier to send someone to jail. But the things I'm doing in my courtroom, like exactly like this, postponing sentencing, putting people into drug rehab, following up with the drug rehab provider, making sure he's going okay, going to see him at the drug rehab, doing all these different things, it takes time, creativity, and a true desire to make a difference. And that's, I think, where we need to galvanize people and inspire people and show them what people's lives can become if you invest time in them.
Is there appellate review in your state?
Not on the sentencing unless we've gone above the maximum.
I see. So how do you create a system which privileges that and encourages that on the state side and on the federal side? One is in terms of resources, there's no question about it. On the federal side, if a judges, I hate to say this, judges need to start getting reversed for imposing guideline sentences. The judge that gives this Mr. X 151 months should be reversed. And it shouldn't be enough to say he intoned the 3553A factors. Intoning the 3A factors, forgive me, are like davening when I grew up. I didn't understand what anybody was saying. They were just, intoning the words. So the Court of Appeals on the federal side could begin to change things if they wished. And the judge that went to probation for this individual, just as you did, likewise shouldn't be reversed unless we get the structures on top. In your case, really, you're talking about a culture. And I would suggest that you do what Dan Free did with the Mississippi judges that he taught, which is have a session of all the judges in which you present cases. Have judges get information, get data about what happened to the people you sentenced. That's what I'm doing now, finding out what happened to the people I sentenced. So if a judge actually cares, they'll know that that 2-year sentence, in fact, led to recidivism, yours did not, whatever. There has to be a feedback loop, in a way. I'm towards the end of my time. I just want to say a couple of generalities here, general statements. There's so much to be done, and it's not enough just to create programs for diversion at the front end. What we have to, there is a long-term strategy and a short-term strategy. The long-term strategy is clearly eliminating mandatory minimums on the federal side. My view is to eliminate the federal sentencing guidelines, reconfigure the Sentencing Commission to be a commission that looks at what works, that deals with these kinds of issues. Long-term strategy. There is a long-term strategy about what we do to the people we've already sentenced. There have been numbers of people who talk about a Marshall Plan for the communities who have been subject to 30 years of mandatory sentencing. And you have to deal with that. The men that I'm dealing with, that I'm following now, their stories are simply extraordinary. The time lost in their lives, the families that have disintegrated because they were put in a prison in the middle of the country, the relationships they may have had, which were not fabulous to begin with, but at least were something. So we have to talk about what do we do to reinstate these communities, to repair these communities. And then there's a short-term issue. It's so easy for judges, not in this room, to say, there's nothing I can do. There's nothing I can do. And there's a wonderful quote that James Forman writes in his book. James Forman Jr. writes about the disaggregation of the criminal justice system. He says, nobody has to take responsibility for the outcome of mass incarceration because nobody is responsible. Even reluctant or conflicted crime warriors become part of the machinery of mass incarceration, and why the system continues to churn even to this day when its human toll has become increasingly apparent. Each one of us has spent the past 30 years saying there's nothing we can do. And of course you can in an individual sentencing case. You could write what you did. You could write it down. You could send it to the Sentencing Commission as a model of what this offender category would look like. You can do all sorts of things in your ordinary sentencing, not just in the diversion. In the diversion issue, you can talk, not individual judges, but we have to figure out a way to talk to the press about what we're doing, figure out a way to talk to the public about what we're doing and what works. So next session, I'll come back with another one. Thank you very much.